after lunch. And I think Hafish and I was just talking before that this is one of the first days during our stay here in Dubai. We had a full nice lunch, so brilliant. So we understand some people are still with their lunch. But we will start this session where we will address two topics that are instrumental pieces of the puzzle to develop the climate regime going forward, the international climate regime. My name is Annette Magnusson, and I have with me co-chair Hafish Khan, and together we will take you through this panel. And welcome to everyone here in the room and everyone joining online. This panel will be divided into two topics. We will do about 30 minutes for each topic, and we will talk about conciliation during the first, and then we will talk loss and damages for the second 30 minutes. And I will take you through the first 30 minutes, and Hafish will take you through the second 30 minutes. And just by way of introduction, my name is Annette Magnusson, and I am from Climate Change Council in Stockholm, Sweden. But I speak here today on behalf of the International Council for Commercial Arbitration, ICA, and in the capacity as co-chair of the ICA panel of experts to develop a draft conciliation annex of the Paris Agreement. And with me here today online, I have two of the members of the panel of experts, Laurence Boisson de Chaussure, who is a professor of international law at the University of Geneva School of Law, and also co-director of the Geneva Center for International Dispute Settlement. There you are, Laurence. A warm welcome. Yeah. And also, I hope we have with us Nicola Swan, who is a partner with Chapman Tripp and based in Wellington, New Zealand.
Hi, Annette.
Yes, there you are. Nice to see you, Nicola. Laurence and Nicola will be sharing some views on the Conciliation Annex as we kick into that part of the program. But before we do, Hafish, do you want to say a few words about the second part of this panel and your guests? And who you are, by the way, for the viewers.
Yeah, thank you, Annette. I'm Hafiz Khan, an environmental lawyer from Bangladesh. Also, I'm a climate change negotiator with the Least Developing Countries Group. I'm currently a member of the executive committee of the Warsaw International Mechanism, and it was my great opportunity to work with Transitional Committee for Loss and Damage as an advisor throughout the year. Luckily, I also acted as a Transitional Committee member for one session, TC4, in absence of my member. He was sick, so it was my great pleasure to act as a Transitional Committee member. So my session, briefly, we would like to see the compensation and liability regime to address the loss and damage. But we know some exclusion clauses are there in the Paris Agreement. So we will try to identify further ways to address loss and damage with compensation and liability. Luckily, we got a member for the Compliance Committee of the Paris Agreement. I'm very lucky that I got Ian Fry here. You all know that special rapporteur for climate change and human rights. Ian Fry was one of the lead negotiator for loss and damage in the LDC group. We call him Guru. So it's a great opportunity to hear Ian Fry and Eunice from Compliance Committee. But I also requested two of my colleagues who are in the blue zone in the negotiation room. I don't know whether they can make time or not, but I got luckily two incredible speakers here. So thanks, and over to you.
Thank you, Hafish. To kick us off and the first part of this discussion on the Conciliation Annex of the Paris Agreement, just a few words by way of background on this topic. So as some of you will be familiar with, that there are provisions on dispute resolution in the Climate Convention, the UNFCCC, Article 14. And this language is also reflected in the Paris Agreement. And basically under these provisions, disputes regarding the application and interpretation of these instruments shall be decided primarily through negotiation or any other peaceful means of resolution of disputes that the parties agree on. And if the negotiation fails, and if the parties have previously agreed to refer any disputes to the International Court of Justice or arbitration, then they could go to ICJ or arbitration to resolve their disputes. However, very few states or signatories to these instruments have made such commitments, which means that the next step of dispute resolution provisions or procedures as foreseen under these provisions will apply, and that is conciliation. The UNFCCC also says that specific procedures for conciliation will need to be drafted, and that has not been included in these instruments to date. So this is the background to the initiative that was taken by the International Council for Commercial Arbitration earlier this year. And in February, the panel of experts was launched and began working on drafting the procedures for a conciliation annex under the Paris Agreement. And this panel consists of experts in dispute resolution, public international law, and of course, climate change and conciliation. And as I said before, we are very lucky to have two of the members of the panel of experts with us here today, who will talk about some of the key elements of the draft conciliation annex. And of course, the whole idea with the draft conciliation annex is that having this, what you could call a gap in the text, having to fill this gap will ensure that should there be a dispute going forward, that the instruments will be in place. And thanks to that, then safeguarding the efficiency of these instruments, as dispute resolution provisions is doing in any legal text. So this is a very, very brief background to the draft conciliation annex that is now presently on the table. And I should say that a draft was worked on all spring. There were consultations during the summer with stakeholders, and now we have sort of a second version of the draft, which is sort of the basis for our discussions here today. So with this very, very brief background, I would like to begin by turning to Lawrence in Geneva, and perhaps ask you to explain to the viewers who are hearing about the idea of a conciliation annex for the very first time, on maybe putting some words on what would be the role of the conciliation annex. Is this something that is really necessary? And what would be the scope of the types of disputes, or the type of context when these rules of procedure would actually be used? Any thoughts on that?
Thanks. Can you hear me well? Yes. So I'm very sorry not to be with you for the COP meeting. What I'd like to say is to put in context what you've said already, that, we have a dispute resolution provision in the Paris Agreement and the Framework Convention, and there is a mix of dispute settlements that were foreseen, both diplomatic and judicial. And as you've said, the first one in almost all contexts is negotiations, if they're not successful. So it might be that the International Court of Justice or arbitration can be resorted to, but you need the agreement of all the parties to a dispute. So there comes conciliation, and I'm insisting on that because conciliation was foreseen as a noteworthy mechanism for solving disputes by states, by the negotiators. Now the conciliation, something interesting, it's seen as a default mechanism. And one thing I think which is important is that it can be resorted to by only one parties to a dispute. So you have a dispute between two states or several states, but if one state wants to resort to conciliation, this is going to be possible, and it's a commitment from the member states of the Framework Convention and the Paris Agreement that they should follow a conciliation procedure. Now, wisely, as you've said, Annette, the negotiators had thought that they would need some procedures for conciliation. And so if you look at Article 14 of the Framework Convention, you see that there is a commitment by the member states to develop a procedure, a conciliation procedure, and to include it in an annex. And this would be a role of the Conference of the Parties. So that's where we stand. And I think that it was very wise from the negotiators to think about conciliation. Why is it so? Because it's a procedure which is flexible. It's a procedure which which allows a third party to intervene. Usually it's a body of 5 members, and we can come back to that. That was what is proposed by the draft annex. And but the outcome is not mandatory. It's going to be a recommendatory award, a recommendatory decision. And I think that's very important because it shows the flexibility of the procedure and the value added of the procedure. The other thing now, to put this procedure into context and why it's needed, it's as we know, there are very few states which have foreseen the resort to a judicial mechanism. So conciliation has great chances of being used, being resorted, and there might be disputes. There might be disputes between the member states. I'm just going to give a few. We know that we have substantive commitments with respect, for example, to transfer of technology, to financial contributions. We have also important issues dealing with the nationally determined contributions. And all these issues could be dealt with through conciliation. So I think that is an important role that the draft annex can play. Let me add also, aside from the informality, that it's not just, I don't think that we're only going to have bilateral disputes. We might have multi-party disputes, and that is important. And there in the draft annex, you will see that there are provisions foreseeing the possibility of having multi-party disputes resolved through conciliation. So that's another aspect that the draft annex is dealing with. The draft annex is also dealing with the consolidation of proceedings. So if you have several disputes which are going on, which can be related and joined, there can be consolidation. So all that is to say that it seems to me that now we have reached maturity with legal commitments, substantial commitments in the context of the climate change regime, but we needed to have something to develop. We needed to develop the procedure in relation to conciliation, and this was foreseen with by the ICA and the 2 co-chairs. We thought that it would be important to think about what would be a good blueprint for conducting conciliation. Thanks, Annette.
Thank you, Lawrence. So there are mechanisms already in the Paris Agreement, compliance mechanisms, and also in the UNFCCC. So how do you foresee that the existing, for example, compliance mechanisms and the conciliation procedure, how should one understand them in parallel?
It's, I think it's a key word of the climate change regime. It's complementarity. We all play a role, each procedure play a role, and they complement each other. So as you rightly said, in the context of the Framework Convention, we have the subsidiary body for implementation. And in the context of the Paris Agreement, we have an implementation and compliance committee. So now the question could be, but why having a procedure dealing with conciliation if we already have these 2 standing bodies? I think that they have a special role, a very important role, both mechanism, both bodies, both committees. They have what I would call a preventive function, in a way that they try to anticipate problems. So how do they try to anticipate problems? In monitoring the behavior of states, in questioning some of the reports and so on. So to be able to identify if there are problems and to see if states are doing all what they can, what they should do for fighting against climate change. Now, so they're anticipating problems, they're anticipating disputes, but it might be that there would be a dispute. And there comes the conciliation procedure. And this is why I think it was important to have this draft annex on the procedure in relation to conciliation. It's when once a dispute has arisen, how to resolve it. And as I've said, I think great chances that it will be done through conciliation.
Thank you for clarifying that. And I think there are some terms here, I think from someone hearing this for the first time, that I know that I myself reacted to that the first time. For example, the term recommendatory award. Coming from the field of dispute resolution, one tends to think that an award is a binding instrument, whereas of course it's recommendatory here. And the phrasing recommendatory award is something that emanates from the UNFCCC. So this is why this term is used for the conciliation annex. And it's important to keep in mind, as Lawrence pointed out, that this is a non-binding procedure. And I think one should also keep in mind that the procedures that are contained in this draft and also that are expected to be in the final version of the conciliation annex are in the hands of the parties. Which brings me sort of to my next question, and then I would turn to you, Nicola, because we have heard a few remarks already here on sort of the instrument of conciliation. And what are the sort of characteristics of conciliation? Could you sort of take us through why conciliation could be such a valuable tool in these precise circumstances that one could foresee in a dispute under the Paris Agreement?
Thank you, Annette, and good evening from New Zealand. It's a real pleasure to be seeing you and speaking to you all this afternoon. Conciliation has a number of benefits in terms of striking a balance for states that are wanting to practically move forward with disputed issues. And that's been recognised right through a number of international agreements where conciliation has been embedded in the treaty provisions, as it has been done here. And for those less familiar with conciliation, it's very well regarded as a flexible, very cooperative and practical way of moving forward on disputes. So as Annette has said, there is no binding award, and that's such an important point for state parties to realise as they're considering this sort of option. There's a recommendatory award which gives some structure to the outcome of the dispute, and it also raises an expectation as the parties are working through the process that there will be a formal outcome at the end of the process. But critically, it's not binding. There's a requirement in the proposed annex that the state parties, consider that in good faith. And yet the process is more than a mediation, which might be another option or form of dispute resolution that the parties might be considering, because you do have the formally appointed 5-member commission, which is what the proposal is currently for, where each side would propose 2 of the members of that commission, and then they would appoint a 5th member. So you do have more structure, even though the ultimate outcome is non-binding. And so by setting up the Conciliation Commission in that way, you're able to build trust and have a degree of openness between the parties in terms of having a sharing of information, but still within a relatively formal structure, so that progress can be made, assuming that the parties have tried to have discussions between themselves that haven't got anywhere to date. So you can see the conciliation rules used, lots of existing examples from the Permanent Court of Arbitration, in UNCLOS, UNESCO, XII, the Convention on Biological Diversity. We've got various recent examples where this kind of structure has been adopted, and those examples are some of the ones drawn on when the parties were putting this into both the UNFCCC and the Paris Agreement.
Thank you, Nicola, and you put it very well. This sort of it's a procedure that is informal, but still you have the structure, right? You have a foreseeing a formal procedure, how many you should be members of the Conciliation Commissions, and I think this is this balancing act between having a procedure that is 100% owned by the parties at all times, but at the same time giving some predictability and having some sort of formal structure. That's an interesting balancing act that was part of the discussion in the panel throughout this year. And I'm thinking when we're speaking about balancing interests here, to take us to sort of one of the details, if you could call it that, but very important one of the conciliation rules and the draft. When we talk about climate change and disputes, and of course this involves a very large portion potentially of public interest. And in those kind of contexts, there will always be need and desire and requests to have perhaps more voices involved in the dispute resolution process than disputing parties. So there will need to be an element of transparency, and an element of bringing in or making it possible for NGOs or non-disputing parties to actually in different ways be part of this process. And on the other hand, there could be sensitive elements of a dispute and sensitive parts of the dispute resolution process where perhaps confidentiality would be something that would be preferred by the disputing party. So this balancing act is addressed in the draft. Could you share your view on how this balancing act has been, how it plays out in the draft, and if it strikes the right chord as you see it? Do we get the balance right here in this draft?
It's a really important question, Annette, and this was something that the working group spent a lot of time exchanging views, and we had a really great representation of views and experiences from right across the world and from different backgrounds. And this issue of how you resolve the tension between two disputing parties who have a particular interest in a particular point that they want to resolve to remove the dispute between the two of them, but being very conscious that under the Paris Agreement, that same issue is going to be relevant for a wide number of not only other state parties to the Paris Agreement or the UNFCCC, but also other groups, international organizations, NGOs, private parties. And so Article 19 of the draft annex has been very carefully put together to recognize the role and the importance of third parties in these disputes playing out, and those third parties being able to participate subject to the supervision and decision of the Conciliation Commission, with obviously real reference to the views of the disputing parties themselves. So you could have the Commission determining whether particular third parties are going to be able to make submissions to the Commission through the process. You can have the parties agreeing to the Commission actually going out and seeking the views of third parties. And so that could be both non-disputing states, but also other third parties such as international organizations and NGOs. And I think that the prevalence of amicus curiae briefs through international disputes, that the increasing expectations of transparency mean that there will be a lot of serious consideration given by Commission members as to how they are inviting third parties to be involved in these disputes, and the amount of space they give to those third parties to make submissions. But I think the draft still strikes that right tone of keeping this an issue that the Commission does need to determine. You can't have non-disputing states coming in without that supervision from the Commission. And the reason that is there is, of course, that the kinds of disputes that are likely to go to conciliation are going to be at that sensitive diplomatic level, and you do need some ability for the disputing parties to be able to work through and ideally progress those with some constraints and protections around that. So there is a fine balance, but I think an important balance struck in the text at the moment. When you think about transparency and confidentiality, and this is very connected, again, there was a lot of discussion on this in the working group that Laurence will remember well, and you'll remember well, Annette. So Article 21 of the Annex specifically deals with transparency of the fact of the conciliation. So the starting point is that the fact that a conciliation is happening is a public matter, and that references the way that the Permanent Court of Arbitration operates. But then the Commission itself is required to decide whether to make the award or parts of the award public, and that there's an expectation that there will be an active deliberation by the Commission. There are also protections in the draft annex at the moment for documents, for example, that a state party might be putting forward as part of the dispute to remain confidential. And so again, there's been a lot of thought put into how to strike that balance so as to encourage state parties to use this structure as a way of progressing their disputes in a sensible way, but being mindful of the significant public interest in having these disputes determined in a more transparent way.
Thank you, Nicola. And since this is one of the examples of issues, I think, in the draft that will be the focus for discussion as we go forward. And it is a draft, so we are now engaged in conversations on listening to the views on this draft from experts. So this presentation here today is part of that conversation, and we have had previous seminars here or side events here during COP earlier here, and we will continue this conversation. So I would just encourage for attendees to reach out to us if you would like to look more closely on the draft and sort of share your views on the draft. Laurence, I know that you may be pressed for time and may have to leave us, so just do you have anything to add to Nicola or not on what Nicola has said, or anything that you have thought of while you have been listening that you would like to add about the draft annex to the audience? Did we lose everybody?
You're just on mute.
Sorry. Yeah, no, it's just to add something maybe also in terms of the composition of the Conciliation Commission that is proposed, is that the parties are going to be the ones to decide about the compositions, the members of the Conciliation Commission. And in a way, they will be able to choose the persons who have the knowledge and the expert knowledge about what is at stake in the context of a dispute. We all know that climate change issues are rather complex, but we also now have specialists. So I think it's going to be something important for states to choose their own members. But even if the Conciliation Commission didn't have the expertise which is required, we've foreseen in the draft annex the possibility that the Commission could ask the parties if it can appoint its own experts. So I think that that's another issue that the group of experts work on. It's the issue of expertise and to guarantee that states have the right proposal and the right proposal for solving their disputes. Otherwise, I think it's also something that Nicola has stressed, which is important. It's a balance of interest. So we've looked at different issues, and it seems to me that the parties are going to find what they need in this draft annex.
Thank you so much, Laurence. Thank you to both you and Nicola for sharing the overview of the draft annex. And I think being conscious of time, we now hand over to the second part of our panel, Hafish and your team. Again, thank you, Laurence and Nicola.
Thanks.
Anna, thank you so much. So, colleagues, welcome to loss and damage regime. You know, COP28 is a momentum for loss and damage climate policy regime. So, the presidency played very important role. So, before COP28, presidency consulted with all the groups whether they can adopt these loss and damage fund and funding arrangement, the recommendation put forward by the transitional committee. But I was involved with LDC group, so LDC group actually accepted it very warmly, and I think other groups also accepted it. So finally, COP presidency adopted the decision at the opening session. That is very unprecedented in the COP processes. But so now that was the COP presidency actually wanted to adopt it so that in the high level segment, the head of the states, they can make pledges. And we do see many places. To be honest, we didn't expect these places. Very interestingly, Arab Emirates also made pledges. This is the first time we do see any developing country made pledges for climate finance. Not only they pledges not only for the loss and damage fund, also $1 billion for to bridge the gap in climate finance regime. I would say this is a kind of huge momentum for climate finance also. So with that said, I will give you briefly, let me give you an overview. That is, you know, there is an institution called Warsaw International Mechanism we established back in 2013, but that was adopted under the adaptation framework. Then on, we had a struggle to go beyond adaptation. Then luckily we got Article 8 in the Paris Agreement, but unfortunately there is an exclusion clause associated with that Article 8. If you look at the decision 1 CP21 para 51, that stated Article 8 of the Paris Agreement does not provide any basis for liability and compensation. Then again, if you look back the COP27, when we adopted the agenda item for the discussion for loss and damage fund and funding arrangement, there was no explicit footnote. So we spent a whole night almost at the 3:30 p.m. We failed to, you know, before COP presidency would like to get the consensus from all the parties on the agenda item so that they can adopt it the opening session. So we had a discussion until 3:30 a.m. in the morning, but we couldn't agree. Later, on 6th November, in the morning, 8 a.m., we agreed on the agenda item. That was funny, actually. There was no explicit footnote, but during the COP session, opening session, COP presidency read out the agenda. There was the exclusion of liability and compensation. And if you read carefully the decision here, loss and damage fund and funding arrangement, you will do see 3 footnotes are over there. So it's a struggle with compensation liability, but we accepted it. But we are now talking about the loss and damage financing within the purview of facilitation and cooperation. So with that said, you know, for my session, we also invited a loss and damage lead negotiator from LDC group. Just he texted that he is involved, he's in the negotiation room, but luckily we got Professor Ian Fry. So I'll be happy to hear Ian Fry, also Eunice, our colleague from the compliance committee. So maybe we can start with compliance committee, and then Professor Ian Fry can give us some ideas how to extend the compensation liability beyond the UNFCCC processes. Eunice, come here.
Thank you and good afternoon, all of you, ladies and gentlemen. My name is Eunice Asienguza. I sit on the compliance committee for the Paris Agreement. I represent the least developed countries. I will begin to start from where I ended. Does the committee provide for liability for loss and damage? The committee is formed under Article 15 of the Paris Agreement. It is a mechanism to facilitate implementation and promote compliance with the provisions of the agreement. And it was established consisting in accordance to Article 15, paragraph 2 of the committee. So what are the objectives of this committee? The objective is to facilitate implementation and promote compliance with the provisions of the Paris Agreement. The committee is expert-based, it is facilitative in nature, and it functions in a manner that is transparent, non-adversarial, and non-punitive. And most importantly, it pays particular attention to the respective national capabilities and circumstances of parties. So under the compliance committee, we do not have a mechanism to provide for liability or even to punish. We do not have that mandate as a committee. We facilitate. We look at the capacities of parties. What has prevented them from complying, and we look at those systemic issues. How can we enable them to come into compliance? So it reflects on the conciliation committee. The conciliation committee that is going to be formed or that is already in place will also look at those modalities. They'll be looking at parties. What are the issues at hand? How can we, it is formed with a gist of helping them to achieve the intentions of the Paris Agreement. So the committee is already in place and it has already started working. If you want to know all the functions of the committee, it is on the website, on the UNFCCC website. Last year, I think it is this year, we received 2 parties that had not complied. One had not submitted biannual communication and another one had not submitted their NDCs. So we received the information from the Secretariat and we wrote to the parties, and as I talk, they have already complied. So when they complied, we didn't publish their names. So I in a way of creating linkages to the conciliation committee, I think it will work also in that very particular manner. Thank you.
Eunice, thank you so much. As Eunice said, the compliance regime in the Paris Agreement non-punitive and non-adversarial. So we don't see any scope to address loss and damage from the perspective of liability and compensation. So, but we'll be very happy to hear Professor Ian Fry what we can take other initiative, other ways. So maybe he can shed some lights on the other opportunities we can explore. Professor Ian Fry.
Thank you very much, Hafiz. Earlier this year, I visited Pakistan and they suffered a huge drought in 2020, a huge flood in 2022, which cost them billions of dollars in damage. And this is, climate change, loss and damage. And that's just one country. When we think about current floods in South Sudan, the hurricanes, cyclones that have affected Mozambique, all of these countries are suffering huge amounts of money. So my sense is that the loss and damage fund is nowhere going to go near the order of magnitude required for dealing with the costs that countries have to face as a consequence of the impacts of climate change. So we have to think about sort of other mechanisms as well. And I was involved directly in the negotiations of Article 8 in the last hours of Paris, and particularly that paragraph 51 that Hafiz was referring to. And I want you to carefully look at that text. So basically, we were put into a small room with the United States. There were 2 representatives from least developed countries and 2 from small island states to sort of hammer out what should be in the Article 8. And the wording we agreed upon agrees that Article 8 does not involve or provide a basis for any liability or compensation. But in our minds, that infers that all other articles of the Paris Agreement do provide a basis for liability and compensation. So we think there are adequate opportunities for seeking liability and compensation for non-compliance with the other provisions of the Paris Agreement. And there have been some interesting discussions about that. And the Philippines Commission on Human Rights put out a very important report that looked at the responsibility of carbon majors to pay for the costs that they're incurring as a consequence of their activities. The Inter-American Court of Human Rights is seeking an advisory opinion brought by Chile and Colombia. And one of the key questions that have been brought through that court is the issue of reparations. And I think there will be some interesting conclusions coming out of that court case. And in comparison to that, and I want to sort of, take us to the other side of the world, we have the Energy Charter Treaty, which has investor-state dispute settlements. And countries are paying in millions of dollars in compensation for taking action on climate change through this Energy Charter Treaty. So countries who are actually reducing their emissions are paying millions of dollars in investor-state dispute settlement arrangements. Italy, which withdrew from the Energy Charter Treaty, is still having to pay out an investor-state dispute settlement, even though they're no longer part of it. Mozambique, the country affected by these cyclones, had to pay out millions of dollars in investor-state dispute settlements. So I don't think we should be timid around the issue of reparations. If countries are already paying out billions of dollars for taking action on climate change, then we should be, seeking compensation measures from the polluting countries to pay for the cost of damage. And this comes within the context of reparations. So I see that, and either this is going to come through court cases and seeking, compensations through court cases, or we need to establish a mechanism that is similar to the investor-state dispute mechanisms, where we have a system where countries can pay the costs of the damage they're causing. Thank you very much.
Thank you. Thank you so much, Professor Jan Frey. So, as he said, he was directly involved with the negotiation of Article 8 in the Paris Agreement. So, and he suggested us some of the way forward, how to move forward with the liability and compensation. And I do agree with him. Article 8 only with the exclusion clause, but the rest of the articles are there and convention are there. We are lucky that we got another compliance committee member. Christina is here. Christina, before you come, Eunice, your colleague from compliance committee, she was talking about the limitations of the compliance committee, that you are not dealing with compensation and liability approach, rather non-punitive and non-adversarial approach. So colleagues, whatever it is, we are very happy that some compensation, to some extent, money. Even if you give enough money to the affected people, it doesn't work. Rather, we are trying to here as a negotiator to establish a comprehensive institutional structure. We got it. Warsaw International Mechanism is there. Under that, there is an executive committee that is working as a policy arm. There is a Santiago network we established at COP25 that is going to be operationalized here. That will work as a technical arm of this mechanism. Finally, the financial facility, that is the loss and damage fund. Now we need to act at the national level, right, to translate all these global policies, because we need to act the local level. With that said, we'll go for a few minutes question and answer. Before that, I'll be very happy to hear Christina a few words to add something, how the compliance committee is working. Christina, would you please come here? Okay, thank you. Yeah. Christina, yeah. Let's. No. Compliance committee member in this session.
Okay. Well, what did you say?
I was just asking how the compliance committee working at this moment.
Yeah, well, we are working. That's already this is on. I guess you hear me. As I said in the morning, I guess you weren't in the opening plenary that we tried a little later. And the compliance committee is operational now, which is a big step compared to last. It was already established in the Paris Agreement itself in Article 15, but it took until 2023, until this year, before it actually could become operational. But this has happened this year. We had our first two initiations of issues that were quickly resolved, which speaks to the effectiveness of the committee. But big tasks are coming, because with the core legal obligations of providing biannual transparency reports, next round of NDCs in 2024, these are core legal obligations which fall squarely under the mandate of the compliance committee. But it's true, and I guess Eunice spoke to that the committee itself has a facilitative function. It's supposed to support parties in meeting their obligations, but it also has a function to alert to cases of non-compliance. I think that's a very important aspect, and at least in the context of the Paris Agreement, this body of accountability is in place, and it is taking its first steps.
I have one more question for Christina. So she's also a law professor. How do you see the current litigation trends? How do you see the potential future for establishing compensation and liabilities beyond the irreparable synthesis?
Yeah.
Like ICJ or other initiatives, local, national, international jurisdictions.
Yeah. Well, I think if we stick with international law and the question of compensation claims, I think we are at a very interesting moment where we have 3 international courts of tribunal being asked for advisory opinions, which in the first step are asked to clarify the legal obligations that exist for states to protect the climate system, protect harm, protect human rights, protect the marine environment. But of course, the follow-up question, and that's actually a question directly put to the International Court of Justice, is what are the legal consequences if states do not comply with these obligations? And here we have the international rules on state responsibility, which is like a secondary set of rules. That if there's an internationally wrongful act, that act gives rise to potential claims for restoration, including compensation. That is just a legal consequence of breaching an international obligation. But the first step has to be taken first to verify what are the legal obligations, and then we'll see what comes. But the question is put squarely to the International Court of Justice, and it's going to be interesting to see what the court is going to say. The IUCN is involved in all 3 of these proceedings. It was invited by ITLOS and the Inter-American Court on Human Rights, and authorized by the ICJ. So I'm with my team, we're drafting the submissions to the ICJ and the Inter-American Court as we speak, and ITLOS we were already present in Hamburg, which is an interesting moment in time.
Christina also ISN law commission chair. So I do request Professor Inyafai to come here, stay a few minutes. We have to hear only few questions.
I thought you wanted to come.
I love how this panel is turning into a town hall meeting. That's brilliant. So do we have any comments from the floor up here?
Very brief and precise because
We have 5 minutes left, yes. And can we take questions online as well? No? Okay, we have a question over here.
If you could be kind to give us your name, your nationality, and who you're affiliated with.
Thank you. So my name is Ghulam Zarwar. I am doing PhD at SOAS London now. So my question is to Ian. Obviously, we have had a good discussion, but still considering the arrangement of the loss and damage fund, and particularly the negotiations with what we are having around the COP, till date, as we see that the crisis is still driven by extreme inequality, right? A global 1% of the reach is emitting greenhouse gases, which is equivalent to 66% of the global port, what Oxfam says. So those polluting elites are not accountable yet. And Christina also addresses the issues of accountability, which is also obviously, encouraging. But what we see is that the finance gap, particularly, right? It is estimated that $400 billion, dollar is needed to address. This is the minimum to address the loss and damage arising out of climate change. And still, till today, probably we are seeing the pledges, quote and unquote, of 50 billion. This COP. So how we are heading towards? Or what kind of world we are leaving for the next generations? Considering the financing, huge financing gap, I would say. Thank you.
We'll take one or two more questions, then we'll come back to the panelists.
Thank you very much. I'm Telsa Mikaush. I am from France and Algeria and a student at Yale University. My question is, to what extent is there overlap between the current loss and damage discussions and mechanisms and the debate around debt relief, in the sense that, for instance, in Pakistan, early warning, things like that are very important, but many developing countries are suffering from the burden of debts that stop them from, at the local level, implementing this type of mechanisms that would reduce the loss and damage. Thank you.
I think these two questions, okay, well, let us take one more question. Professor Kamza, please.
Thank you. As Dr. Hafiz just mentioned, my name is Professor Dr. Kamruzzaman Majumdar. I am representing Center for Atmospheric Pollution Studies of Stanford University, Bangladesh. So my question is actually this question is from many people from the third world country or developing or underdeveloped country. Like we even don't have our capacity to assess what are the losses and damages are being made due to the climate change. So what mitigative measures that we can even expect to get from the global north to get the technical support to assess our loss and damage? So is there any provision in your discussion for those countries like Bangladesh? Thank you.
Let us take one more question from this side. Lara, is there any question from this side? Sarah, no.
Yes, exactly. Well, just speaking about, we heard about investor-state disputes. I was just building on Thalsa's question. How does that factor in? How do you, Paris Agreement is state-based agreement. How do you bring in corporates into the talk of loss and damage, particularly the support to get the money in, but then the support to siphon it out and apportion it correctly? What support can lawyers give and the private sector give to help enable that?
So if there is no other questions, we'll get back to the panelists. I don't have to specify any of you to respond. Rather, let us allow 1 minute for each of us. So, and online speakers are also here. So we can start with Anna or your online speakers.
I think I heard most of the questions relating to the loss and damages functions. I don't know if my panelists would like to chip into that conversation. But otherwise, I will just give the floor to the people next to me here to answer the questions, and maybe give Lawrence and Nicola a few minutes to think if they would like to chip in.
I think the first question went to him, but I would want to speak to someone who asked about the capacity to assess loss and damage. He's asking about the technical financial help that can be obtained in order to address those two. I think the challenge, the negotiations are ongoing, and those are the main challenges. We do not have the reliable data. Countries don't have, especially us LDC, we do not have the data, we do not have the funds, we do not have the technical experts that is needed to address some of these issues. And that goes specifically to our lead negotiator on loss and damage. He'll address that. Thank you.
Well,
I guess most of the questions go to you, and then I wasn't quite privy to the discussions previously, but I think back to your question about the corporate sector. I think one issue is getting private support into the fund as well. I think that's going to be absolutely crucial. We know that public funding is limited, and we already have a number of other funds. But getting the money to the level of as it's needed will be a major challenge. But I think we need to look alongside with litigation, and that is not a either or. It's a double strategic. Exactly.
Yeah, please.
Thank you. And directly, yes, there are estimates that current loss and damages are in the order of $400 billion. So we're talking orders of magnitude far greater than what public finance can provide. In my report to the UN General Assembly last year as Special Rapporteur, I made a recommendation that the UN Secretary General should form a group of finance experts who can think outside the box and come up with innovative sources of finance to meet the order of magnitude required. And there are some interesting ideas out there, and we need to bring those together and see if we can have that sort of international dialogue. Discussions about IMF drawdowns, taking from that, there's, as indicated, issues around debt relief. Can we, have a proper mechanism to deal with debt relief, to remove the burden on those countries? I visited Honduras earlier this year, and they have a huge debt burden, and they can't pay for the damages of climate change impacts that they're suffering because of the huge debt burden. Other ideas of taxes on fossil fuels. If we think about the profits that Saudi Aramco made last year in the billions of dollars, why are they making so much profits at the expense of people who are suffering? So we need to think about those, and can we bring that conversation into the loss and damage fund, process, and hopefully we'll have that opportunity. Thank you.
Hafid, before you close, then if I can just throw in my 2 cents on Lara's question or comment on the when we're talking about corporates and the loss and damage. This is in a parallel discussion that is currently happening when it comes to the development of international investment law and the new international investment agreements, sort of the modern international investment agreements. And I think one discussion that is going on there, which ties into that, is to provide clear provisions in the treaties for counterclaims for states. And that is an unclear issue under many current treaties. And there we have a few examples in case law where counterclaims have been successfully filed by the states. But I think being very clear on the fact that counterclaims can be forwarded by states is one way of sort of addressing the specific issue of corporates causing harm. So I just wanted to add that.
Very briefly, Lara Corporation, actually during the transition committee works, we agreed a wide range of varieties of sources. So private sector can contribute. Yesterday I was talking with some philanthropists out there.
I think maybe the people online want to hear you.
There's one final question from a viewer online. So Mumita asks, Mumita's from Bangladesh, and the question is, do you think climate litigations can help to ensure compliance with the Paris Agreement and effective implementations of it? And if yes, how far so?
Yeah, she's my colleague. She's working on climate litigation. So I rather ask her to explore further. So we can explore, we can spend a good amount of time on this question, but very briefly, Lara, I was talking with philanthropists yesterday. So they are really interested to commit some money, place some monies. To be honest, I suggested go slow. Let us wait. Is there any private entities come up? But it will not happen here at COP28. But the litigation regime are trying to make them liable. If you look at the German RW case, if you look at the Holcim case in Switzerland, at this moment, Momita and we are some of are involved to do some research on attribution size, feasibility studies, also carbon emissions by the corporations. But we legal committees are really taking different initiatives at the different jurisdictions, particularly to make liable the corporations. For your question, actually, if you look at the funding decision para 12 in the covered decision that we agreed sources, right? There is a fight with a comma. That if you look at the paragraph 12, there are 2 commas over there, before voluntarily and after voluntarily. So developed country parties didn't want take any obligation to fund this loss and damage fund. They argued with the Article 9 of the Paris Agreement. They said clearly they don't have any obligation to fund loss and damage, but convention is there. We also agreed in Paris Agreement, other parties in opposition to do so, they can also fund. Even the developing countries, they were very reluctant to take any obligation to fund here. That the taboo is broken. United Arab Emirates put some money, good amount of money in this fund. So let's look forward. But we legal communities, this is the time to take very bold initiatives so we can break this taboo and can support the global community, particularly affected communities like Bangladesh, affected states like Tuvalu, right? Thanks all of you for attending this session. Due to time, we need to close it. I will hand over to Annette, please.
Well, thank you, Hafiz. And I would just reiterate what you just said. Thank you all for joining us. And thank you to all our contributors here on stage and online. And we hope to continue this conversation going forward. Thank you.